Well, hello and welcome. We're going to be starting chapter 8. This is the second chapter in our examination of the court systems. So this part is really a precursor to the trial and then parts of the trial itself. Again, because of my background, we're going to be focusing a little bit on the practical way in which much of this is done inside the North Carolina courtrooms, and we'll look at the most common procedures in there, and those would be usually district court, although we'll mention superior court and the appellate courts. And the first slide, of course, is our learning objectives. Basically, just a kind of an overview of what we want to look at. But let's go on to the first point. So, a few questions to talk about, really, before we dig into the chapter. And I find this is a helpful way to think about quite a number of things as you study them or you seek to learn them. And that is to ask basic questions first. So one of the basic questions is, what kind of criminal justice system does America have in regards to its courts? Well, we call it the adversarial system. And since we've always grown up with it, I don't think we really question it. But the idea behind it is this: that by having two adversaries in the courtroom, hence the name adversarial, you have the prosecutor and the defense. They compete against each other. And through that competition, the truth emerges, and you can establish if someone did or did not commit a crime. Now this begs an obvious question, and it's one that we don't ask, and your book certainly doesn't address, and that is, but does this really lead to a discovery of the truth? And like I said, asking fundamental questions like this is often the beginning of wisdom. So ask yourself the question: if you're having two people argue like this, and you could call a courtroom an argument, does that really produce the truth? And then if you say, well, yes, it does, the sense of competition, which is a very American idea, brings out the best in people. Okay, but doesn't the side with the greatest resources have the advantage? So if the New York Yankees were playing the Cleveland Mudlarks, the T-shirt junior baseball team, wouldn't the fact that the Yankees had years of training, experience, the massive resources behind them, give them a huge advantage? So would that be a fair game? Would it likely produce, who's the best? I mean, if one side's got overwhelming everything. Also then, if you say, well, if it's discriminatory because it's designed against those without really power or money, if you reject that, and I think you can reject that, I'm not saying you can't, ask yourself this next question. Do you have objective evidence that the system works? So if I asked you this question, what percentage of the time, or how often, does the American criminal justice system, in the trial sense, get it wrong? So one way to look at that would be how many innocent people are convicted, or how many guilty people go free. And do we even know those numbers? How would you study that? And if you say, well, yes, it does fail, well, why does it fail? Because that could lead you to mechanisms to fix it. Okay. The final point here, overall look at, is what alternative systems are there? So much of the world does not have what we call the adversarial system. They have an inquisitorial system, where there are certainly lawyers, you're represented, but the judge plays a more active role. Now, again, this varies dramatically from country to country, and there's no evidence that those are any better or any worse, but that's one of the major alternatives. So is it worth thinking, what are they doing right, or what are we doing right, and how could we make it better? How could what they do make it worse? Okay. One of the ways I approach this is a micro lectures, trial by combat, because this goes back to our adversarial. The ideas of two sides competing to prove guilt or innocence is a very long history in the Western world, and in some ways our adversarial system is very much trial by combat, and perhaps we need to look at that. So those questions I raised in those broad introduction are something I think you should, with me, take a quick look at in micro lecture 8.1, and we'll leave it there for now. Okay, so how does it work specifically for North Carolina after arrest? So let's suppose we have a suspect who's arrested for, say, burglary. That's a felony. I suppose it's a first-degree burglary charge. It's a very serious charge. In North Carolina, after an arrest, the defendant has the right of either initial appearance or first appearance in North Carolina, and they kind of differ a little bit. So initial appearance is typically for people who commit a misdemeanor. First appearance is typically for people who are arrested for committing a felony. Now, if you notice in this slide, there are some abbreviations there. NCGS 15A-501 subsection 2, 15A-511. That refers to North Carolina General Statute, and that is going to be the title or the chapter, 15A, and then the section that you're going to find these rules. So 15A is the part of the North Carolina Code that talks about criminal procedure. So we have two options. If it's a misdemeanor, we call it the initial appearance. That can be in front of a magistrate. If it's a first appearance, that's usually going to be in front of a judge. Okay, so regardless of how it works, much of this is going to be done again and again. So let's call it appearance. During initial appearance, you're going to be informed of the charges against you. When you're being arrested by a police officer, and I've heard lots of clients say this to them, what am I being arrested for? They do not have to tell you. But eventually, you have a right to be informed of the charges against you. Then the magistrate or the judge should determine if there was sufficient probable cause for arrest. So an example, I don't know if anybody saw, and this is sometimes some of you are probably watching this or listening to this months afterwards, but a CNN crew was in Minneapolis filming the protests and riots, and they were taken into custody by the state police. They hadn't been committing a crime. So if they went in front of a magistrate, I would assume they did, there was a probable cause hearing, and the magistrate said, okay, Officer O'Malley, why is the CNN crew in here? And he said, well, you know, I was told to arrest him. Well, that's not good enough. Tell me what crime they committed and why you believe they committed it. If the prosecution here, if the police can't really provide that information, you're going to be released. If, however, it's deemed that yes, there is probable cause, we're going to have a bail being set, and this will be the first probability that you might have counsel appointed. Now, first appearance, which are very close, told of your right against self-incrimination, told of your right of counsel, you're given a copy of the charge, you're going to look at it and tell the prosecutor if it's proper or improper. There's going to be some pre-trial release conditions, and if necessary, a probable cause hearing will be scheduled. So what happens to most people? Well, most people, for most crimes, since most crimes are not felonies, they're misdemeanors, and even the felonies very often are nonviolent felonies, the question becomes, should we hold them in jail? And I'm intentionally using the term jail. It's not a prison. Should someone remain in jail until the trial begins? Well, if you believe, and our system says it, that someone is innocent until they are proven guilty, you've got to have a good reason to hold someone that you presume to be innocent in a cell for, could be a long time before their trial starts. So most of the time, we release them. And there's really two ways that you can be released. First, you can get what's called an ROR. This is very common, particularly for minor crimes and certainly nonviolent crimes. An ROR says you are going to be released on your own recognizance. ROR, released on recognizance. And you simply say, okay, John Doe, you've been accused of, say, a minor crime, jaywalking, and we're going to let you go. You're scheduled to come back for trial. Let's see, we arrested him, say it's June 1st. Your trial is set for July 15th. Please come back and we'll have your trial. And obviously for most people, they're going to come back. Sometimes we're a little bit leery that they're going to come back or not. We're a little bit concerned, so we're going to say, well, we want to make sure you come back. And what we're going to do is we want you to let us take some of your money or your property. You're going to pledge that. The court's going to hold on to it. And if you come back for trial, we'll give it back to you. If you don't have that bail, you will remain in jail. And this is one of the first places where the obvious advantage of wealth comes into play. So again, two people get arrested. One is Bill Gates, a billionaire. One is John Doe, someone who is destitute, very poor. And they set a bail of $10,000. Well, for Bill Gates, who is worth billions, $10,000 is like a nickel. For someone that has never seen $1,000 in his whole life in his hand, $10,000 might as well be 10 billion. So bail is the amount of money set, and it's designed to make people come back. It shouldn't be designed to punish, although arguably sometimes it does. So what is bail? Bail is actually one of those things that is at least referenced in the Constitution. The 8th Amendment of the Constitution says, excessive bail shall not be required. Well, like much of the Constitution, and you might get a little sick of hearing this, what excessive means has not been defined very well. You are not guaranteed that you can get bail set, but if bail is set, it should not be excessive. Now, how does bail work? Well, let's go back to our John Doe who was arrested for burglary. So John Doe is arrested for burglary. He goes in front of a judge. Judge says, well, this is a pretty serious crime. You didn't kill anybody, but it's pretty serious. So I'm going to set your bail at the amount of $25,000. If you want to get out of jail before your trial comes along, you have to post bail of $25,000. So how does he do that? Well, typically he gets on the phone and he calls a bail bondsman, who are private individuals who will go down to prison and say, okay, John, do you have $2,500 in cash? And let's suppose that our John Doe has that much money. He gives it to the bail bondsman. Now that is the bail bondsman's to keep forever. This is his profit, in other words. The bail bondsman then goes to the court and posts a bond in the amount of $25,000. So again, you can see here that the amount of money you have really begins to have an impact. If you can make bail, you're going to get out of jail. If you can't make bail, you're going to stay in. No set definition exists, and in micro lecture 8.2, I think we'll talk a little bit about should there be some bail reform and what are some of the issues around it. Okay. Assuming that we have, and different states have different requirements about this. North Carolina requires this within 15 days after the first appearance, that there is a probable cause hearing. Now this is often also waived. If there was sufficient evidence to make the arrest, the defense attorney, if there is one, or the defendant might say, I don't want a probable cause hearing. But assuming that it's necessary, this is going to be held in front of a magistrate or a judge. And again, they're going to determine if there's enough evidence to show that it is likely that the defendant committed a crime. Not proof beyond a reasonable doubt. Not there's some suspicion of it. So not any, not all, but likely. As I said, this often is waived. However, sometimes it can be used because really at the probable cause hearing, what you have is the beginning of the process of discovery. That's with a capital D. Discovery is when each side finds out the evidence that the other side has. So if you've got my client John Doe and I'm the defense attorney, and I want to have the probable cause hearing because I want to see what evidence they have, at least initially, to establish my guy did it. So if they say, well, we have a videotape of it, well, that's pretty good evidence. That let me know the videotape exists. Now, I probably would have found the videotape later. It would have been turned over to me under Brady, but it's important that you can use the probable cause hearing at the beginning to start to get a look at what evidence the other side possesses. Okay, grand juries. Now, I don't have any experience with grand juries in a practical sense because North Carolina doesn't typically use grand juries at the state level. Some states do, we don't. So how does a grand jury work? Well, before an arrest, a prosecutor goes in front of a special, which is usually a large number, and the numbers can be 15, 18, 20, it can be a large number of people, and says, hey, I've got evidence that John Doe committed a crime. Now, an interesting thing here is there's nobody representing John Doe. There's no cross-examination. There's nobody saying, well, that evidence is admissible. It really means that if the prosecutor has even a weak case, but some case, he usually can get a grand jury to indict. There is no counter arguments made. So nobody says, here's why he's innocent. Now that means that you almost always, as a prosecutor, can go to grand jury. If the prosecutor doesn't get an indictment from a grand jury, two things are going on. One, he didn't want the indictment. And sometimes prosecutors go in front of grand juries because they don't want to dismiss a charge themselves, but they don't want to go forward with the case because maybe it's unpopular politically or something. So they go in front of a grand jury, they don't provide enough evidence, or they allow more evidence in that shows it may not be true, and the indictment never happens. The saying in the law among us lawyers is, you can indict a ham sandwich if you try. It's that easy for a prosecutor to get an indictment. He could do whatever he wants. Okay. This again is a demonstration of where the power is in the system. The idea of prosecutorial discretion. Prosecutors have immense power. First thing, of course, they can decide, will someone be charged? Then they can increase a charge or decrease a charge. They can decide to drop all charges, or they can decide to prosecute. Now, sometimes the prosecution will say, you know, at this point, I'm going to drop the charges. I'm going to, and the Latin term is nolo proseque, which means to not prosecute, basically. But just because a prosecutor drops the charges now before the trial doesn't mean he can't bring them back later. So one of the things that is going on here is, even though prosecutors typically have more resources than the defense, it's not unlimited. So they do have limited resources, so they will prioritize cases. Obviously, they're far more interested in a murder case than they are jaywalking. And at a certain point, if they know that prosecutions are going to be very long or very difficult and obtain very little, they may not prosecute. Okay, so what are some things that the prosecution considers? Well, one of the things is, and this opens up some criticism of our system, is the prosecution has to ask, is there enough evidence to charge? Now notice I'm using the term charge and not convict. So one of the things that the prosecution will do is they will engage in overcharging. They might know that if they go to trial, they can't get a conviction under 5 counts: burglary, arson, murder, assault with a deadly weapon, and rape. They might know, well, you know, I'm not going to be able to prove all 5 of those. But if I charge all 5, if I overcharge, right? Even if I'm unlikely to be successful, it gives me a far, far stronger hand in negotiating a plea bargain. It's kind of like when you go to buy a car. The first price you get is not the price that you should pay. What they're going to do, and this is for any large ticket item, is they're going to name a number which is high because they know they're going to be engaging in a negotiation with you, and that if you're good, you're going to be able to lower that price. So often they'll look and see how much they have. Then how serious is it? The more serious, the less likely they'll drop a charge. What's the victim like? The more sympathetic the victim is, the more cooperative the victim is, the more reliable the victim is, the more likely that the prosecutor will go forward. To use a cruel example, if a nun was sexually assaulted or a prostitute was sexually assaulted, even though it's certainly possible that both of those crimes occurred, a jury and the public would be far more sympathetic to the nun who was attacked than to the prostitute. So a DA is aware of what the real world is. They are aware of what the limits of their power are, how a jury might behave. So they will look, okay, what's the victim like? Are they a reliable victim? Are they cooperating? Are they, and the term is attractive, and I don't mean that in the physical sense, but is it a victim that people will feel sympathy for? And how cooperative are the defendants? Or how powerful is the evidence they have? Do they have a videotape of the attack? Well, that's great. Do they have the eyewitness only from one drunk who was on meth who also saw a dragon? Well, that's pretty weak evidence. All right, so after you're arrested, you can enter a number of pleas, and I'm going to include the fourth plea down there, which you may not have heard of, but it's a North Carolina option. So the two that almost everybody have heard of is you either plead guilty or not guilty. So guilty essentially says, I did it, go ahead and punish me. This means there's not going to be a trial. Not guilty or no guilty means I didn't do it, let's go to trial. Now, there's two other options. No contest, also called nolo contendere. It's very like a guilty plea, but you can't use it against a person civilly later. And there's also no attorney fees generally associated with it. Then there's what's called an Alford plea, where I'm innocent, but I say you have sufficient evidence to convict me, and I won't oppose you. Those are both pretty rare. Most of the time it's either guilty or not guilty, that should be. Okay, this next slide depresses me, to be honest about it, but let me read you the statistics here. 97% of federal cases and 94% of state cases are plea bargained with a guilty plea. And that means that even though I'm going to spend the hour or so necessary to go over trials, that if we look at federal cases at least, only in 3% of the cases are we having real trials. Instead, we are plea bargaining. Now, there's three broad categories of plea bargaining: charge bargaining, sentence bargaining, fact bargaining. So charge bargaining says, okay, plead guilty, we drop one or more of the charges or reduce them. So we'll reduce it from, say, first-degree burglary to second-degree burglary, or we'll reduce it from 5 felonies to 1. Sentence bargaining says, plead guilty to burglary, but we will give you a suspended sentence. And then fact bargaining can be important where you agree not to release some facts of a case or put them in the official record. That can be important, although it's pretty esoteric. So it's really the first two, charge bargaining and sentence bargaining, you see most often. So why do we have plea bargains? First of all, the prosecution gets a quick win. It saves the prosecution, which means the government, time and money. All right, well, why would the defense take a plea bargain? Well, the big reason is you get an assured sentence. You're going to avoid a harsher penalty. And to be honest about it, the prosecution often threatens you to get you to take the plea bargain. They will say, well, look, if you do not take this plea bargain, where we're only going to charge you and convict you of 1 felony, we're going to charge you with 5, and if you're convicted of all those, you're going to have a longer sentence. It'll save money. That's another reason defendants take it. Typically, defendants have to pay back money even for state-provided attorneys. So remember, when you get read Miranda and it says you have the right to an attorney, if you can't afford one, one will be appointed. Yes, under that Miranda and under Gideon v. Wainwright, you are entitled to an attorney, and the state will pay for it. But at the end of the day, if when the trial's over, the state different states have different procedures for this, will come to you and say, give us the money for it. You owe us $500, $3,000, $2,000, $10,000 for our defense attorney that we provided for you. Cop a plea or pay the price. Now this is from some sentencing statistics. This is the average sentence for federal drug defendants by whether they take a pretrial or trial. And there's lots of reasons why these numbers are different, but it's pretty shocking if you look at it. If you interpret this in the worst way, first of all, you notice that almost everybody's taking a plea there. There's 24,000 pleas. There's only 747 trials. But you'll notice that if they go to trial, you're facing more than 3 times the sentence as if you take the plea. So if I came up to you and I said, you may be innocent, but you may not be able to prove it. Tell you what, plead guilty and take a year in jail, or plead not guilty, I'll proceed with felony charges, and if you're convicted, you'll have 3 years in central prison. Well, you're going to take a year in jail, you're going to take 3 years in central prison. Okay, speedy trial. Sixth Amendment of the Constitution says, at least in part, that the accused shall enjoy the right to a speedy and public trial. Now, there's no statutory right at federal law, but in North Carolina, and this is North Carolina General Statute 15-10, you do have the right to a speedy trial. Interestingly enough, North Carolina has no statute of limitations for felonies. So if you're at Thanksgiving dinner next year with mom and grandma says, yeah, back in the 1930s, me and John Dillinger robbed some banks. You could say, really, grandma, cool story. Then you can go and make a phone call and have grandma arrested. And grandma can't say, well, that was 90 years ago. It doesn't matter. North Carolina has no statute of limitations for felonies. Now, some states do. And North Carolina does have a statute of limitations for misdemeanors. That's 2 years. But for felonies, nope, do it whenever you want. You also should be aware that there is very often delays for trial. They're very common. And if we delay a trial because we have to gather evidence, or we delay a trial because of a crowded calendar, that does not trigger a violation of the Sixth Amendment. You might think it should, but it doesn't. So it can take more than a year to go on trial on serious felonies. It's not unusual, even in North Carolina, for a case to drag on for a year or 2 years between arrest and trial. All right, the jury. The Sixth Amendment guarantees you the right to a jury in criminal trials. However, and there's been an amendment to the North Carolina Constitution on this recently, this can and often is waived. And the question is, do you want a jury? Who do you trust more? You know, we have another joke in the bar which says, don't trust your life or your property to 12 people too stupid to get out of jury duty. Because a lot of people who wind up on juries are underemployed, undereducated, and not paying attention. Most of the calls I get from friends about the jury system are, hey Jay, I just got a jury summons. How do I get out of this? So, what's a jury like? What's it composed of? Well, first of all, what's it drawn from? It's drawn from what's called the venire, V-E-N-I-R-E, which is a list of all possible jurors. Now, North Carolina uses registered voters plus driver's licenses, and that's the pool. If you don't have a driver's license and you aren't registered to vote, you're not going to show up in the venire. You're not going to wind up in the jury pool. Typically, juries are composed of 12 people. At a minimum, you have to be a U.S. citizen. You cannot have a felony conviction. You have to be relatively healthy. You have to be able to read, write, and understand English. After we get the venire, and so there'll be a jury impanel. Let's suppose I'm doing a jury trial, and they'll bring in 18 or 20 prospective jurors. At this point, we go through the process of voir dire. Now, that, again, pronunciation, you're going to hear it a lot of different ways. Voir dire, voir dire. The reason there's so many pronunciations, not that it really matters, is that it's really bad French Latin. It's really not even proper Latin. But it means literally to speak the truth. And it's when each side, the prosecution and the defense, question all these potential jury members to see if they're going to get on the jury. Well, as you question them, there's a couple ways that you can keep them off the jury. One is if you find a problem that relates to the case, you can then challenge them for cause. So let's suppose I'm questioning someone who's sitting on our jury, and it turns out that he is the brother of the prosecutor. Well, I could go to the judge and I'd say, Your Honor, I'm going to challenge this juror for cause because clearly it's improper for him to sit on the jury. And you can have as many of those as you need. If you find 10 people that are prejudiced, or 10 people that are drunks, or 10 people that are crazy, you can challenge them all and keep them all off the jury. But at a certain point, you're going to run across people that you don't want on the jury because maybe they look like they're going to convict your client, or if you're the prosecution, that they're going to acquit. So you don't want them on. Well, you have a limited number, and this is going to vary a little bit from jurisdiction to jurisdiction. You have a limited number of times that you can simply preemptory challenge them. So you ask them a question, you get that feeling, or you know that this person is most likely to rule against you, and you simply go, Your Honor, I'm going to preemptory challenge this person, and he's off the jury. Now, one of the things that unfortunately in our history went on was prosecutors routinely excluded jurors because of race, ethnicity, or gender. They're not allowed to do that anymore. But if the prosecution does do it, and it goes on, there's no question about it, we don't presume, so let's suppose we have a black defendant and it winds up an all-white jury because the prosecution excuses the 3 possible black jurors that could sit on it. Well, you might say, well, that means that he violated this rule. Well, as the defense attorney, I've got to prove he did, and that's pretty hard. It's a burden on the defense, which means a lot of the time the prosecution simply gets away with it. And of course, now wait, that's a defense attorney's perspective there. All right, after the picking of the jury, we do have a decision that we're making, and this is one that's made between the defense attorney and the defendant. Fifth Amendment says no person shall be compelled in any criminal case to be a witness against himself. It's called taking the fifth. This is where you refuse to answer questions. Now, if you're in a criminal trial and you're taking the fifth as a defendant, it doesn't mean you go up on the stand, answer questions when the defendant asks you, and then when the prosecution says questions, you say, I'm going to take the fifth. No, you don't testify. So if you do that, the prosecution can't say, well, ladies and gentlemen of the jury, if he was innocent, he would have been up here talking. He's not allowed to do that. The prosecution can't say it. There are lots of good reasons why people don't take the stand. Maybe they have a temper. Maybe they'd be a bad witness. Maybe they appear inappropriate to most other people. Maybe their demeanor is shocking. There's lots of reasons. Maybe something will be brought up that'll cast the person in a very bad light. I had a defendant once who was accused of possession of drugs, and when they were conducting the search for the drugs, various forms of pornography were found. Well, the drugs were bad enough, but if I had to go in front of a rural North Carolina jury, and I had to, as the defense attorney, I had to explain that yes, my client possessed some rather distasteful pornography, then it was going to really poison the jury against him. So we didn't put him on the stand. If you grant immunity, you lose the right to plead. So if I say, okay, I'm not going to prosecute you for a crime, then you cannot claim the Fifth Amendment. You lose that. It only exists if you face trial. Presumption of innocent and standard of proof. So 2 things here. The theory is a suspect is presumed innocent. I'm going to say, in fact, this is not true. A presumption of guilt seems to apply for most juries or judges. Even though I say this in a courtroom, even though I've argued this in front of juries, not as much in front of judges, I truly believe that most juries want evidence that your guy didn't do it. They're not willing to accept that he's innocent unless you give some evidence to them. Standard of proof necessary to establish guilt. You must show proof beyond a reasonable doubt that the defendant committed the crime. Now, in theory, that's pretty high. But again, there is a bias in favor of the prosecution. So lots of jurors, and I would say judges as well, kind of take the attitude, well, he wouldn't be arrested and he wouldn't be sitting next to Mr. Chapman if he hadn't committed some type of crime. So it's not as high a standard as you might hope or believe. Okay, so how does the trial go? First part is opening statements. Prosecution goes first. It stands up and it says, here's my case. The defendant is guilty. Here's the witnesses I'm going to provide. Here's the evidence I'm going to provide. Pay attention. Sits down. Then I get up. The defense attorney gets up and he argues that the defendant is innocent, or possibly that the prosecution can't prove that the defendant committed the crime. And opening statements are really an attempt to paint a story. And it's one of the few times in a North Carolina court where you can get up. You can stand. Most of the time, unless you're addressing a judge, you're sitting at a table. It's not like Law and Order. After opening statements, we have the admission of evidence. Now, not all evidence is admissible. There's three big gatekeepers, three big things that block or frame the evidence. One, it's got to be relevant. It's got to in some ways matter. Two, it's got to be material. It can't be really, really minor. It has to be important. And three, it's got to be competent. It means it's trustworthy. So relevant, material, competent. Those are the three big gatekeepers. If you can't get through those three things, your evidence isn't going to get in. So I've had students say to me, well, shouldn't all evidence get in? And I say, well, no, of course not. Suppose you're on trial for a murder, and you've said your whole life, well, all evidence should get in. And the prosecution goes, well, ladies and gentlemen, I'm going to call a psychic, and the psychic's going to come in and testify that the defendant killed John Doe. And, you know, a psychic comes in, and you're probably saying, well, who believes in psychics, or people that claim they can talk to the dead or have spirit guides or things like that? Well, a significant number of Americans do. And if there's enough of them on a jury, you could be convicted because some psychic said, well, Ashtar, my Atlantean spirit guide, said the defendant killed the individual. It wouldn't be competent evidence. Might be relevant, might be material, but it's not competent. There are two broad categories of evidence. We look at testimonial evidence, and then we look at real evidence. Testimonial evidence is the testimony of witnesses. Real evidence are your physical items. So, besides that division, we can also break evidence down as direct, circumstantial, and prejudicial evidence. These are not necessarily mutually exclusive categories. Direct evidence is something that proves things without needing any other evidence or support. So if I say, how do you know John Doe committed the burglary? And you say, well, I was standing on the street. I saw him break into the house. I saw him creep in through the window. I saw him take the DVD player out the window, and I saw him run away. Well, that's direct evidence he committed the burglary. Circumstantial evidence is things, and this can be very strong. It's not the basis of an objection. It can indirectly show something. How do you know he committed the burglary? Well, I saw him walking in the street at 8:02, and at 8:05 I saw him stepping out of the defendant's house, or standing near the defendant's house, and he was holding a DVD player. And then I saw him running away. Well, I didn't see him break in. I did find out later a DVD player was stolen. That's circumstantial evidence he's the one that did it. Maybe someone broke in, dropped it, this guy came up, saw it lying in the bushes, picked it up and walked. Okay, great story. Don't believe it, but great story. So there is circumstantial evidence. Final category here is prejudicial evidence. And this is evidence that really just inflames the emotions of the jury. And it does little or nothing to prove an issue in the case. And this is going to be, going back to our relevancy, competency, materiality, this is going to be a challenge to get in. Sometimes things are really shocking, but they're going to get in, even if they're really going to inflame the jury. So I had a case once where there was a fight about the admissibilities of photographs. So there had been an accident and a child had been injured and had bled over a concrete sidewalk. So the question we were arguing about was, should we show the jury these very lurid pictures of blood on the sidewalk? Or should we show it in black and white or not show them at all? And my argument was that since we were the insurance company, we had admitted that our client was liable, that the nature of the accident didn't matter. What mattered was the injuries. We said we're liable, we're going to pay. And they wanted to show these lurid photographs because that would inflame the jury. You would say, oh man, that's really terrible. Well, yeah, it's terrible. That's bad. I'm not arguing against it. I'm saying we're responsible. Now, what are your medical bills? So prejudicial, it's kind of a two-edged sword. You got to be a little bit careful about it. Okay, the prosecution has to establish the body of his case, the corpus delicti, and each element of the crime. So if you took the crime of first-degree burglary in North Carolina, here are the elements of first-degree burglary, and you don't need to know these, but I'll break them down for you. You broke, you entered, and occupied, that's the third one, dwelling, sleeping house, or apartment of another, at night, with the intent to commit a felony therein. So the prosecution, if it was trying to prove first-degree burglary, would have to prove all those. If they didn't, for example, prove that the burglary occurred at night, then it's not a first-degree burglary. If they didn't prove that someone was home, then it's not a first-degree burglary. They have to prove everything. Typically, witnesses will offer, during the prosecution's chief case, direct testimony. They'll come up and they will tell a story. The prosecution is not supposed to, on direct, lead a witness, not say, tell us what happened next, tell what happened next, tell what happened next. No. Asked to say, what happened, in your own words. Now, the defense has the right to cross-examination, and this is absolutely vital. It's not as important in some practical ways, but it's absolutely vital because if you're going to lie, the most difficult thing about a lie is not telling it. Everybody can tell a good story. I mean, there are great stories out there. There's a ton of ghost stories and UFOs and goblins and things that go bump in the night. But, you know, if someone says, well, yeah, me and Billy Bob were down at the swamp. We were taken up in an alien spaceship. No, that's a really interesting story. Well, okay, let me just cross-examine. Hey, were you and Billy Bob drinking? Well, yeah, we had a couple. What's a couple? A couple six-packs. Oh, a couple six-packs. Have you ever, when you drink a little bit, seen a few things? Oh, yeah, I've seen some wild stuff. Okay, well, by cross-examining, you brought out more of the truth or cast doubt upon the veracity of the truth. So cross-examination, if you're not allowed to do it, that is a clear violation of the Sixth Amendment, and it's grounds for mistrial. So one of the things that sometimes will come up, and you'll hear this when cross-examination is going on, is the issue of hearsay. So the example of this I could give you in a somewhat comical sense is this. Sometimes, you've played the game, for example, probably as children, where you form a line and the first person whispers something to the second, who does the third, the fourth, the fifth, the sixth. And you might have started off, the first person whispered Afghanistan, Bananistan. And by the time it gets to the other end, the 10th person that is repeating what they heard, you'll get something crazy like Hadrian's toenails. Where the hell did that come from? Well, just because people were corrupted in how they repeated it over and over again. You do not have cameras in your eyes nor tape recorders in your ears. And you might have heard something, it might have been important, but you may not be able to repeat it verbatim. An example here is you have all heard at one point in your life the Gettysburg Address. It's a short speech, only slightly over 100 words, 200 words, Yet I dare say none of you, if I asked you right now without looking it up on Wikipedia, no cheating, could repeat it for me verbatim. Having said that, there is lots of ways to get hearsay into court. It is theoretically inadmissible, but there are 24 exceptions. So very often, hearsay, which is an out-of-court statement being repeated, does get in, although it's viewed with some suspicion. After the prosecution goes, now it's up to the defense. So in theory, I don't have to offer any case whatsoever. Practically, I got to create a hole, show a lie, or a mistake in the state's case, or my guy's in trouble. Sometimes I can raise specific defenses. Alibi, self-defense, insanity, duress, or entrapment are all defenses I might raise. The next point is after I'm done, the prosecution might say, well, I want to call a witness about the defense's witness. And then after they do that, I might stand up and say, well, I want to call a witness about the witness the prosecution called about my witness. You don't see that a lot, but it can happen. However, 99 times out of 100, prosecution goes, defense goes, we're done. Now we do closing arguments. And unfortunately, I have to go first as a defense. I go in front of the judge or the jury and I make an argument. What did they just see? Argue that probable cause wasn't established and my client's not guilty. Then, of course, the prosecution gives its closing arguments. And I'm a great believer that closing arguments and opening statements are very important, but that they have to be tailored to the juries. They have to be tailored to the population that's listening to them. After this, the jury, if there is one, goes back and makes a decision. It may be the judge, but it's often a jury. So before they go back, the judge says, here are your instructions. Here's the charges, here's how you consider the evidence, go back in the courtroom, talk about it, and let us know what your verdict is. Now, this is done in secret. Verdicts are only supposed to be based on evidence that's admitted in court and basic common sense. And the jury really has two options. They can come back and say, yes, John Doe did it, he's guilty, or no, John Doe didn't do it, he's not guilty. If they can't reach a decision, if they go in there and they vote 6-6 and it's a tie, or 9-3, or 11-1, and one juror says, nope, 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 even if it's the other way around, if 11 want to acquit and one wants to convict, if the jury is split and they cannot reach a decision, it's called a hung jury. At that point, they come back, they tell the judge dismisses them, you can have another trial, and double jeopardy does not apply there. Double jeopardy is the idea that you can't be tried twice for the same crime. If you do get a not guilty verdict, so famously O.J. Simpson was found not guilty of killing his wife and Ron Goldman, her waiter. I don't care if a day after the trial you had found a videotape of O.J. Simpson killing her and him. It wouldn't matter. You could not try him again. I mean, he literally wrote a book called If I Did It. It takes some guts to write something like that. Maybe something else. But if you are found not guilty, you cannot retry. Now, what about if someone's found guilty? So suppose someone's tried for burglary, they're convicted. And they decide, I'm not going to appeal this. They convicted me of third-degree burglary, which is a year in jail. The prosecution says, no, it should have been first-degree burglary. We want to appeal it. Nope, can't do it. If the defendant won't appeal the guilty verdict, the prosecution can't. So if there's no verdict, you can have a retrial. If the defendant appeals, you're going to have an appeal and possibly another trial. But if the defendant is not guilty, there's no new trial. That's the Fifth Amendment. It says no person shall be put in subject for the same offense to twice be put in jeopardy of life or limb. All right, I mentioned appeals. Appeals should be pretty familiar to you, but basically they come from trials or other appeals. And you can file for a writ of habeas corpus. Your book mentions that. What's a habeas corpus? A writ, first of all, is an order. Habeas corpus means literally produce the body. But appeals are only made on matters of law, and I've discussed this before. You do not appeal based upon the facts of a case. You don't say, hey, they got it wrong. They factually decided those are my fingerprints. You can't do that. You can argue that the fingerprints shouldn't be admissible, that they made an error of law, but you can't argue the fingerprints aren't yours. An appeal means a higher court will review the decision about the law and determine if the lower court made a mistake. Now, 90% of appeals fail, which means most are not successful. It's very rare that an appeal goes up and is successful. It may be a delaying tactic, it may take time, but they're typically not successful. So sometimes we have wrongful convictions. A question I get quite a bit. What happens when someone that we know later is factually innocent is convicted of a crime? Now, where there were DNAs, based upon DNA alone, 12.6% of felony convictions are wrongful. Now, that's a pretty high statistic. Let's just say it's 10%. It means that we're getting this wrong 1 time out of 10. Why? What's the problem? And that's just when DNA is present. You have to ask yourself, the question is, what about all these other people that are in jail and there's no DNA evidence for guilt or innocence? So why is there wrongful convictions? Well, as I said before, you don't have cameras in your face. There's misidentification. People can say, yeah, that looked like him. I'll give you an example, although many of you haven't seen me. I'm a relatively tall white male, and I was in a country where I was towering over some of the people, and they walked into a room, and there were 3 or 4 of us foreigners there, and he called out my name, and he knew who I was because he had met me before, but he literally told me, oh, all you foreigners look alike. I said, really? I'm the tallest guy in the room, the only one that's balding, the only one with a beard. He goes, I couldn't tell you apart from this guy. I said, really? He's 6 inches shorter than me. He doesn't have a beard, and he's got blonde hair. So we do misidentify. Sometimes it's based on a cultural perception, sometimes it's based on a physical perception. Faulty forensics. Sometimes we get it wrong. I mean, we say fingerprints are really accurate, and that's true. But very often we don't have a complete fingerprint. We have part of it. We have a number of points on the fingerprint that agree. Sometimes we have police misconduct. Sometimes we have false confessions. Sometimes people will confess to crimes they didn't commit for different reasons. Sometimes we have informants who provide false testimony against someone because they're going to receive a material reward or they're going to receive a lighter sentence. Sometimes we have prosecutorial misconduct. Sometimes prosecutors want that conviction so badly, and they really believe that they're helping, not hurting, and the result is an innocent person goes to prison. Okay, so are trials fair? You can ask the question, because don't forget, if you're saying, well, 12%, how bad is that? You also have to remember that means that 12% of the people who commit crimes get away with them scot-free, including a homicide. Do the guilty go free? Do the innocent go to jail? If the system is flawed with 12%, what can we do? What fixes would make the system better? Should we adopt another system? Can we adopt another system? These are all questions for you. I'm a good deal older than most of you, and I'm ready to turn things over. So for you out there, think about these issues. What can we do to fix it? All right, on that note, right around 50, this is about 54 minutes. I'd like to keep it right around an hour or so with a bit of a break. That's going to be lecture 8, and we'll pick up with lecture 9 next. Good night.